In our country, there are certain lands which are owned by the state. It was necessitated to make better provisions for the colonization and administration of government land in the Punjab. So, the Colonization of Government Land Punjab Act 1912 was enacted on 12th of June 1912. So, this act applies to certain areas by order of the provincial government. It may be safely maintained that this area is called colony area. In order to administer colony land, schemes are prepared and people are encouraged to make use of this kind of land. So we have got the Colonization of Government Punjab Land Act. Its preamble shows that the government has enunciated a scheme for the purpose of regulating, administering, and for colonization of the government land. Section 10 of this act states, I'm going through this section. The Board of Revenue, subject to the general approval of government, may grant land in colony to any person on such conditions as it thinks fit. Number two, the provincial government may issue a statement or statements of the conditions on which it is willing to grant land in a colony to tenants. Number three, where such statements of conditions have been issued, the collector may, subject to the control of Board of Revenue, allot land to any person to be held subject to such statement of conditions issued under the subsection 2 of this section, and the collector may, by written order, declare to be applicable to the case. Number 3, no person shall be deemed to be a tenant or to have any right or title in the land allotted to him until such a written order has been passed and he has taken possession of the land with the permission of the collector. After after possession has so been taken, the grant shall be held subject to conditions declared applicable thereto. Now, if we deeply go through this section, we find that there should be land. Number one, there should be land owned by the state. If the land is not owned by the state, then this act shall not be applicable. So this act applies only when the land is owned by the state. It should be declared colony land available for allotment. So far as the land of the government is concerned, all lands are not colonies, but the land which is declared as colony is regulated by this act. So the second condition precedent for the application of this act is that there should be colony land. Next, how to deal with this property? A scheme is to be prepared for the purpose of sanctioning for disposal such land. Number one, there should be land. Number two, it should be declared as colony land. Number three, the government should prepare a scheme for the proposal of this land. So when the government prepares a scheme for the purpose of disposal of this land, then there is a statement of condition is to be issued by the state. So the statement of conditions of a scheme will regulate the allotment, transfer, delivery of possession, and proprietary rights relating to that part of the land which falls within that scheme. So the grant is to be given in accordance with the conditions and possession is to be delivered. So for the purpose of disposal of this property, for the disposal of the colony land, the grant is given under the conditions which are settled in the statement of conditions. So the rights title of tenant are to be regulated under statement of conditions. A tenant before acquiring occupancy rights is not permitted to transfer the tenancy without consent or permission of concerned authority. Any transaction of transfer without permission shall be void. So this section 19 of the Colonization of Government Land Act shows that the property granted to a tenant is not transferable by him at his own will. When a person under the scheme gets allotted a land, he shall cultivate it, he shall bear the fruit, he shall do what is permissible under the scheme. But he shall not be allowed to dispose of this property by way of sale, by way of gift, by way of exchange. But so far as the inheritance is concerned, the right of tenants will devolve upon his successors according to the law of inheritance. But only this part and this style, this way, this method, and this is the only way when the title of the tenant is transferred to his legal heirs. Otherwise, under section 19, nobody can transfer the land without permission of the concerned authorities. So it is a condition precedent for the purpose of allotment of the land. It was held in 1991 SCMR, page 1415. I'm going through it. Section 30 provides that after acquisition of property rights by a tenant, he shall cease to be subject to any statement of conditions. In other words, till he is governed by the statement of conditions, he shall not be allowed to transfer the property. But the moment he gets the proprietary rights, he shall cease to be subject to any statement of condition. Now it is crystal clear that administration, colonization, allotment, issuance of scheme in relation to his land, then transfer of proprietary rights or transfer of property rights are within the jurisdiction of revenue authorities. So this act, if we go through it, we find that how the property is a colony land, then how a scheme is prepared, then how it is allotted, then how the possession is delivered, and how a tenant is regulated by the scheme or the statement of conditions. So all these facts, events, and factors are done under the supervision of the revenue authorities. So in order to perform functions smoothly, no other court, forum, or tribunal should hinder its way. Once the law describes a particular procedure, when the law prescribes how to regulate the colony land, then there is a forum for the purpose of determination of all these rights, liabilities of the tenant under the law. So when we go through this act, we find that the revenue authorities are under the direct administration and control of the colony land, and they are the only authority who can execute the scheme prepared by the authorities. Section 9 of CPC says that civil court has got the jurisdiction to try all suits of civil nature unless their cognizance is expressly or impliedly barred. So a bar is imposed on the jurisdiction of civil court. If there is a bar on the jurisdiction of civil court, then the civil court shall not try the matter. For the purpose to safeguard the rights of the tenants and to make the smooth running and execution of the schemes, Section 36 has been introduced in the Act. I am going through that Section 36, which reads as follows. A civil court shall not have jurisdiction in any matter of which the collector is empowered by this Act to dispose of, and shall not take cognizance of the matter in which the provincial government, Board of Revenue, or collector, or any revenue officer exercising any power vested in it, or any other revenue officer exercising any power restrain it or in him by or under this Act. So the reading of this section explicitly reveals that in a peculiar situation, civil court has got no jurisdiction, because Section 36 clearly indicates that when the authorities are empowered by this Act to dispose of and take the cognizance of the matter, and they are empowered to do certain acts, then the civil court shall have got no jurisdiction. So at this point, we find two ways in this section. Number one is which bars the jurisdiction of the court, and other is which gives the jurisdiction to the civil court. The word empowered by this Act is important. It requires greater consideration and concentration to determine. It shows that if the revenue authorities have the power to deal with the property under the scheme and the state land, then the civil court is not empowered. But when the revenue authorities are not empowered, then the civil court shall be empowered. The reading of this section explicitly reveals that in a peculiar situation, civil court has got no jurisdiction, but there may be certain grounds whereupon civil court may assume jurisdiction. Now, what is the law of the land at this moment for the purpose of determining the jurisdiction of the court is that sometimes under section 36, the civil court has got no jurisdiction. But under certain circumstances in the same section, it is inferred that the civil court has got the jurisdiction. So the point of determination of jurisdiction lies in section 36. It not only bars the jurisdiction of the civil court, but in other words, it also provides the jurisdiction to the civil court. When the civil court is empowered, when the revenue court is empowered, then the civil court cannot take the jurisdiction. But if they work beyond the empowerment, then the civil court, being a court of ultimate jurisdiction, shall have the jurisdiction. So in 2008 CLC 1373, suit on the basis of assumption, apprehension, presumption, surmises, and conjectures. Civil court has no jurisdiction. Civil suit is not maintainable because the Act is very much clear that what powers are to be exercised by the authorities, and the authority is not entitled, is not authorized, not empowered, not having the jurisdiction to go beyond it. But if any person assumes that such and such act is going to happen, so on this assumption, conjecture and surmise, civil court shall not have the jurisdiction, because there will be no material before the court to determine his assumption or presumption. Section 36 is further elaborated in 2007 SCMR 554. Bar under section 36 would be available only where authorities acted within their jurisdiction but not otherwise. So this authoritative pronouncement explicitly maintains that when the authorities act in accordance with the law promulgated in the said act, the civil court shall have got no jurisdiction. 2000 CLC 159, in matter in which the collector, additional commissioner, or the Board of Revenue is empowered to dispose of the matter, the matter stand disposed of within lawful authority and within the exclusive jurisdiction of the revenue authorities. So in this situation, civil court shall have got no jurisdiction. It explicitly maintains that when the collector, commissioner, additional commissioner, or the Board of Revenue is exercising the powers conferred upon him according by the law, then the exercise of those powers will stop the civil court and will ask the jurisdiction of the civil court. In that situation, civil court shall not be entitled, shall not have the jurisdiction to adjudicate upon any matter which has already been decided with the jurisdiction by the competent forum. Now, another authority is 2018 YLR 1950. Matters of allotment, determination of terms and conditions of allotment, delivery of possession of allotted land, cancellation of allotment for violations of terms and conditions of allotment, or grant of proprietary rights of state land to the allottees exclusively fell within the jurisdiction of revenue hierarchy. So this is a very important authoritative pronouncement which decides that what is within the domain and jurisdiction of the revenue hierarchy. And anything which is beyond that, if any authority goes beyond that, then it shall be beyond the scope of that authority. And any act performed or done beyond his authority, beyond his jurisdiction, gives jurisdiction to the civil court. Now there are examples and illustrations which give jurisdiction to the civil court. 2008 SCMR page 521. When action of authorities was without jurisdiction and void, plaintiff was within his rights to maintain suit before civil court. Then there is another authority, 2007 YLR 1696, where revenue authorities act beyond the provisions of law and without jurisdiction, bar contained in section 36 is inapplicable. Then another authority, 2021 MLD 2129. Civil court would have jurisdiction to look into the matter even if the jurisdiction of civil court was otherwise ousted under any enactment, including the Colonization of Government Land Act 1912, as well as Punjab Land Act 1967. When the action had been taken in a mala fide and malicious manner in excess of jurisdiction or without jurisdiction, and the agreed person had been left without any remedy. So there are a lot of authoritative pronouncements on the subject. Section 36 has been elaborated several times by the superior courts that how far the jurisdiction is ousted and how far the jurisdiction is provided. So far as the basic principle is concerned, U by jus, E by remedium. Where there is right, there is remedy. The law does not recognize that a person has a right and on its infringement he will not have the remedy. So the remedy is always there. So where lies the remedy? Firstly, it lies within the jurisdiction of the authority under the Act. And secondly, if the authority fails to exercise the right, then the civil court shall have the jurisdiction to exercise. So the nutshell of this above discussion is that when a revenue hierarchy are empowered to perform certain functions, then the civil court shall not interfere with it. And but when they exceed their jurisdiction, they act beyond their jurisdiction, then of course civil court, being a court of ultimate jurisdiction, shall adjudicate upon the matter. Now it is crystal clear that Colonization of Government Land Act provides certain powers to the revenue hierarchy. So those powers are exercised by the authorities themselves. But they are not allowed to destroy the right of a person, and they are not allowed to go beyond their jurisdiction. So simply we can say, when the revenue court has got the jurisdiction and exercises the jurisdiction in accordance with law, then the civil court shall have got no jurisdiction. But if the revenue court fails to exercise its jurisdiction, then the civil court shall have the jurisdiction to try the matter. So the civil court is a court of ultimate jurisdiction, and whenever any person has a right and his right is infringed by the authorities themselves, then he may resort to the civil court to seek the declaration that the right and was not properly exercised by the revenue authorities. They acted beyond their jurisdiction. Their act is void. Their act is malafide. So far as the act is concerned, it gives certain powers. Those powers are limited, and the revenue authorities cannot go beyond that powers. So, at the end, in a simple word, we can say that the civil court has got the jurisdiction if the revenue courts go beyond their jurisdiction. Now, there is another question that, so far as the revenue authorities are concerned, there are certain schemes for the purpose of appeal, review, and revision in that hierarchy. So the law says that without exhausting the remedies available, you cannot go to the civil court because it is a basic doctrine of equitable that you should respect the law of the land. And when the law prescribes a particular mode to get the relief, then you are bound to adopt that mode. That mode is certainly adopted before going to the civil court. So, in the simplest word, we say that after exhausting the remedies available to a party, if the party finds or if the law permits that the authorities exercise the jurisdiction not in accordance with the law but beyond the jurisdiction, then he may move the civil court to seek the redressal according to the law, and his relief is given as to which he is entitled.